Hi, this video podcast is on the referendum process in California. As you may know, the people have the power to approve or reject all or parts of a statute. Historically, most referendum efforts have either failed to qualify or have been rejected by the voters. An important note is that the filing of a valid referendum challenging a statute stays the implementation of that statute until after the vote of the electorate. So for example, on the November 8th, 2022 ballot is Proposition 31, which is a referendum of Senate Bill 793 that was enacted 2 years prior in September of 2020. Now, proposing a referendum can be done to approve or reject, but of course, rejection is almost every instance when it's used. And it can be done for an entire statute or parts of a statute. There are 4 types of bills that are not subject to a referendum because they go into immediate effect. Those are urgency clause statutes, statutes calling elections, statutes providing for tax levies, and appropriations for the usual current expenses of the state, which are the budget bills. And just like an initiative, a referendum is done by presenting the referendum petition to the Secretary of State within 90 days after the enactment date of the statute, or earlier, but not after the 90 days. Before circulation of a referendum petition for signatures, a copy has to be submitted to the Attorney General, who then prepares a title and summary of that measure as provided by the Elections Code. Now, a referendum can qualify for the statewide ballot up to 31 days before an election, which is different than an initiative, which has to qualify at least 131 days before an election. Since July of 2011, referendum measures can only appear on general election ballots. Once a petition is filed, a county elections official has 8 working days to determine the raw count of the signatures submitted and then report their findings to the Secretary of State. The Secretary of State certifies the petition based upon the signatures collected. And for a referendum petition, it's 5% based upon the votes for all candidates for governor at the last gubernatorial election. Once on the ballot, the law is repealed if voters cast more no votes than yes votes on the referendum. So if you are against the law, you vote no. If you are for retaining the statute, you vote yes. And a referendum approved by a majority of voters takes effect on the 5th day after the Secretary of State has filed the statement of votes for the election at which the measure is voted on. If the referendum petition is filed against just part of a statute, then the remainder of the statute is not delayed from going into effect. The California Secretary of State's office, like the initiative and recall, has prepared a complete list of all the referenda measures that have been placed on the ballot or circulated for signatures, but did not qualify for the ballot. There have basically been about 90 attempted referenda since 1912. Between 1912 and 2016, a total of 89 referenda were titled and summarized by the Attorney General for circulation, and a total of 39 failed to qualify, so that's 44%. 50 referenda, or 56%, qualified for the ballot. Of the 50 that qualified for the ballot and were voted on, only 21, or 42%, were approved, and a total of 29 were rejected, which is 58%. So in most cases, referenda are in fact rejected by the voters, meaning that the enacted statute goes into effect as adopted by the legislature and the governor.